and good afternoon from Venable LLP's office here in Washington, D.C. This is Jonathan Pompan, co-chair of Venable's Consumer Financial Services Practice Group. Here we are. It's a new year, and once again, members of our Consumer Financial Services Group will provide a preview of what to expect in the year ahead on the consumer financial services legislative and regulatory fronts, along with observations about ongoing and new trends. Of course, we won't be able to cover everything in our session today, and there's no shortage of recaps and updates already available and content even on our website. And then, of course, most of these topics, in fact, probably all of them, are eligible for deeper dives that will be written and spoken and webinared out in the future. But now it's time to get grounded and woken, and against which we will have several panelists weigh in on. So joining me today are colleagues that, like me, are in the trenches every day, involved in everything from counseling clients on new products and services to defending compliance and business decisions and advocating positions for regulatory reform. I'm joined by my partner, Andy Arculin, formerly of the CFPB. I'm joined also by Allison Baker, also formerly of the CFPB. And then Ellen Burge, Andrew Bigger, Laura Biddle, Meredith Boylan, and Josh Ramey. Not able to join us, Jerry Sachs, who's also a former enforcement attorney at the CFPB, FTC, and DOJ, and contributed to this presentation. So all members of Venable's Consumer Financial Services Group, and again, all in the trenches each and every day with members of the consumer financial services sector. So let's turn to our leadoff panel. Josh, Allison, and Andy, let's discuss what's going on with the new Congress, policymaking and investigation. And Josh, let's start with you. And as something we've heard a lot of lately, elections have consequences, and there's now a Democratic-run House of Representatives, while the Senate remains Republican. It's just by a slim margin, though. So as this all sinks in, having officially happened last week, what is the impact, in your view, for the consumer financial services industry in the near term and in the far term?
Yeah, well, the biggest impact on the consumer financial services industry is that Maxine Waters is now chairwoman of the Financial Services Committee, and what that's going to do, it's not going to create new laws. We have a divided Congress with Democrats controlling the House and Republicans controlling the Senate. So the idea that new consumer protection or new consumer regulatory bills are going to make it through the process is really unlikely. However, what it does mean is a whole new spotlight is going to be shined on this industry, and it's going to be shined on this industry by the chairwoman and the committee, which I think will be a more left-leaning committee, given that a number of the new freshmen, who many of you might have been reading about over the past week or two, are likely to land on this committee. And through investigations and legislation, will be addressing things that they believe went largely unaddressed over the past 2 years. Just a note about the chairwoman. Underestimate her at your peril. She has been preparing for this role for 30 years, certainly in earnest over the last 10, as she's seen it getting closer and closer to achieving this milestone. This is a big deal for her. This is a big deal for people in her world. And she looks at these issues, the issues she's now in charge of, through the lens of the 2008 financial crisis. For her, and the way she thinks about it and talks about it, 10 years ago or now 11 years ago was yesterday. It is still looms very large for her. And in her thinking, a large contributor to the crisis was large financial institution and non-bank consumer lending. Now, there's a lot of other causes for the crisis. We all know the stories. We've all read the books. But this part of it is the part that she's focused on, and she sees her number one role on this committee as protecting consumers. I put a quote here in the pitch that underscores that in order to prevent another crisis. So that's her mentality. It's an important thing to understand. She'll do that by focusing, I think, in two areas. One is the CFPB itself, both through oversight investigations of Mulvaney's most recent actions. She will address those with legislation as well to sort of undo some of the recent decisions, which my colleagues will touch on over the next hour. And she will focus on, at least for now, mostly large institutions that have gotten into the headlines for various consumer malfeasances. However, I think those that I think what I would counsel clients or folks in this area to think about, and if you're concerned about getting attention from the committee, I think those that have had dealings with the CFPB over the past 2 years, and any of that has made headlines, may find some attention from this committee, or those that get in the headlines in the next 2 years may find themselves getting attention from this committee. So that's what I think it means. I think, you might ask, well, what about over in the Senate? I think the Senate, you've got at least two presidential candidates on the Senate Banking Committee on the Democratic side, one very notable one in Elizabeth Warren, and she will use that platform and I think work with the Democrats in the House to sort of echo and bring a lot of those messages over to the Senate. Sherrod Brown being the other possible presidential candidate on that committee and the ranking member. However, they don't have the gavel, and I think that committee, for the most part, will be a relatively sleepy place. So I think the action is going to be in the House, and I think they will be putting a lot of pressure on the CFPB to at least slow down in some of the recent directions that Mulvaney has been taking it. I sort of see the name change back from BCFP to CFPB as maybe like a first sort of fig leaf or olive branch from Kraninger on that front, but we'll see.
Certainly a fig leaf to all of us that got used to saying CFPB. So there's certainly going to be no shortage of legislative proposals that'll get churned out of the House, some of which are classics that'll make a reappearance from prior Congresses. Some of them are going to be very specific to actions that have transpired in the last several years related to the CFPB, and particularly the last 2 years during the end of the Cordray era and beginning of the Mulvaney or Trump administration era for the CFPB. But there's going to be no shortage of investigations too. It's already on record saying sort of split the time and multitask, and some of those investigations may be of the agencies, including the CFPB, but also of industry too, and industry players, which I think is notable. Now, Andy, I'm reminded that you joined us from the CFPB, of course, which in many respects was delegated by Congress through Dodd-Frank, a lot of the ability to shape the law further without congressional involvement. Rule writing authority for a host of statutes that in many senses had never had a rule writing before if they were housed at the FTC or in other respects. So, for example, in debt collection rule writing that we'll talk about a bit later and others, there is the potential and in fact, perhaps more likely than not, going to be some movement in that area. But I'm curious where you put the balance of power right now between the House, the Senate, and CFPB, because to some extent it seems right now the advantage could be at least with the House to the extent it's going to shine a light on topics that hadn't otherwise had lights shine on it during the Mulvaney era.
That's right. But one thing I would point out is the CFPB still is a very independent agency, and Kraninger is now confirmed. She has a 5-year term. One thing she will have to think about and be mindful of as she gets into her tenure is fulfilling the agency's statutory mission. She is removable only for cause, but one of the causes is neglecting her duties as director and not protecting consumers. My prediction is Kraninger will take some actions to make sure that she's not coming across as a director who's dilatory and not protecting consumers. So there will be some action by the agency. One of the things we'll have to keep an eye on, the agency has statutory authorities under various to do rulemakings in various areas. Those statutory authorities would only change if there is new legislation. To Josh's point earlier, that's unlikely to happen right now, but the agency has a ton of authority to do rulemakings. They also have obligations to do lookbacks on the mortgage rules, which are underway. They have the debt collection rulemaking, which they're in the process of proposing now, and so on. As far as Congress and the role that Congress will play, I would expect the House, in particular, to shine a light on the agency if the agency is proposing to aggressively roll back, for example, the payday lending rule. They have the political means to influence the public. At the end of the day, however, the CFPB is still independent. The CFPB has its own mandate, and Congress cannot, without passing new legislation, take authority away from them.
And Allison Baker, you're also an alum of the CFPB, and you've represented some companies in some high-profile litigation against the Bureau and even challenged its authority in some of those cases. Generally, should companies or sectors that have been under the microscope already during the Cordray era, are they going to be put through the ringer again now by the House?
Well, it's hard to know. I think in some instances what you might see the House do through its oversight powers is question some of the decisions the Bureau made or didn't make during the Mulvaney era and maybe the Kraninger era as well. I also think what you're continuing to see is an uptick in the numbers of state attorneys general investigations looking at certain sectors of the economy, the financial services economy, and specifically those that are consumer facing. So I'm not sure that, a lot of these companies in certain sectors are going to, quote, be put through the ringer again. I'm not sure that the ringer has stopped, candidly. I think from my vantage point, we continue to see a real emphasis, especially from a core group of Democratic state attorneys general, which we'll discuss later, a particular emphasis and interest in certain sectors that also dominated some of the Cordray era agenda at the Bureau. And I think that I suspect that Congresswoman Waters will take her cues from that, but also has her own agenda. And so I don't think you're going to see I think you're going to continue to see a certain relentless look at certain sectors.
Hey, Josh, I know you don't have a time machine, but if the House and Senate committees call up or send a letter asking for testimony or even threatening a subpoena, and someone wants to avoid that for themselves or their sector, is there something they could do now or should have done? And then prospectively, what tools do you want to have to work with?
I think all councils should be and probably are aware of the vulnerabilities within their companies, and certainly I think for this committee especially, headlines are going to drive it. But I think there's sort of a level underneath, and we'll get into this in some of the investigation discussion, a level underneath threatening a subpoena or even asking for testimony, which is, hey, as we've been subpoenaing documents from the CFPB or other companies, we noticed your company came up in it. We saw your name here, and we'd like to have some additional discussions. And the reality is that when you get those questions, I think you go up and you cooperate. And I think again, companies will find themselves in that situation as they're looking for facts and they're trying to understand kind of what's been going on at the CFPB for the past 2 years. That doesn't necessarily mean that your CEOs are going to find themselves behind a witness table, on live television. In fact, I think that's going to be, those kinds of incidents are going to be really reserved for the larger companies, the higher profile issues. But, I think the committee will be very aggressive in asking questions of all sorts of different companies and how they've dealt with the CFPB.
Right, and it bears.
And I know that's already happening, actually.
It bears mentioning too that House Financial Services Committee, while it has primary jurisdiction and influence in this area, it may not be exclusive to that. There may be other avenues that are taken that shine a light on issues related to consumer financial services companies.
That's true. I mean, certainly some of this comes up through the Federal Trade Commission, which is under the jurisdiction of the Energy and Commerce Committee, and of course the Government Oversight Committee in the House and their counterpart in the Senate can look at whatever they want.
Well, great. Thanks to our leadoff panel, Josh, Allison, and Andy. And coming up, more on those rulemakings that Andy mentioned, and it could get complicated. And then there's, of course, FinTech challenges or opportunities. We'll get to that, too, in a moment. But first, states wield an enormous influence over the consumer financial services sector, and consumer protection issues and regulation aren't always partisan. In fact, in some cases, Republican AGs have taken the lead on issues. So with us to talk about all of it, Meredith Boylan, who litigates and defends enforcement actions brought by states, and more also from Allison Baker, who also does many of the same. Of course, others also at Venable have been involved there, and I'll ask questions on the take on all of those. So, Meredith, your practice and mine and others in our group over the course of a year, we'll see several state investigations and enforcement actions. Sometimes those are one-offs or referrals from state supervisory agencies, stemming from an examination of a regulated entity, but others seem to be coordinated and have a higher purpose. Sometimes, in fact, systemic actions and oftentimes multi-state actions that can go on for years. So in fact, just a few weeks ago, for example, multiple states settled with a significant debt collection and debt buying investigation that covers a host of practices and signals expectations. There's been similar ones in the student loan space and others. But those are years in the making. And others sometimes, again, are on a shorter time frame. What do you make of the current state AG landscape?
Right. Well, from a literal perspective, when we're looking at the map right now, you can see that we're pretty evenly divided amongst the states between Republican and Democrat AGs. The AGs have characterized 2018 as the year of the Democratic Attorney General. I should say the Democratic AGs have characterized it as that. And they're coming off a pretty good election cycle where they've managed to flip 4 key seats as well in different states that were previously governed by Republican AGs. So, as far as what we expect to see going forward, I think that there are certain causes that unite both sides of the spectrum, and that includes lending and specifically student lending. As we'll discuss later, there have been some pretty notable bipartisan, multi-state investigations and settlements that have produced pretty hefty fees and burdensome consent orders that these various consumer companies have to undertake. I think that the current landscape will continue to see certain of the Democratic AGs who are potentially striving for higher office to push, agendas that they think will resonate with consumers and with their constituents. But I also think it's notable that there have been a unity on some issues. The Republicans, of course, are taking issue with some of the Democratic-leaning AGs and their pursuit of actions around and against the executive office and the president and some of his business industries, and also the policies that the executive branch and others have been undertaking in the healthcare sphere and the immigration sector. So, I've been wondering whether that would detract from some of their consumer actions, but I haven't seen that amongst our clients. It seems that the AGs are able to balance their portfolio in a pretty effective way, where they can take on these, political hot button issues, but also pursue more traditional consumer protection type cases. The Republican attorneys general have indicated that they're, going to continue to press for certain deregulatory actions, and that they see the softer touch with respect to regulation as really benefiting the economy and growing jobs and encouraging innovation amongst different industries. So, they seem to be pretty far apart, but again, it's interesting to see that the trajectory on some of these investigations involves a very strong representation from both sides of the table.
And Allison, we're going to talk about specific initiatives in a bit, but what strikes you about the posture the state AGs seem to be in now?
So during the Cordray era at the CFPB, there were kind of 2 categories of enforcement actions that I think you could say his agenda championed, and not just him, but others at the Bureau. One had to do with actors in the consumer space who were there but not because of consumer choice. For example, mortgage servicers, student loan servicers, debt collectors. The other being financial services companies that aim their products or services at vulnerable consumer segments, students, service members, senior citizens, et cetera. Those categories of enforcement actions are continuing, and in many ways even larger in scope and depth with the state attorneys general. We continue to see that. We continue to see a focus on the offering of products or services for consumers when it's not necessarily a product or service that a consumer could choose in the marketplace, if you will, such as servicers, collectors, debt collectors, mortgage servicers, student loan servicers. Similarly, vulnerable consumer segments, students being at the top of that list. We continue to see a spike in interest in those areas, and I don't think that that's going to change, even if Director Kraninger is more assertive and aggressive in her enforcement regime than, say, her predecessor, Mr. Mulvaney, was. And so that's really what we're seeing right now, Jonathan.
Right, so the states have really upped the game. And Meredith, I know you and I worked on a matter that while it was started in an examination, it was just as impactful as if it had been an investigation and the company had been unlicensed. So it was something that otherwise would have been dealt with through an examination process, but it seemed like in there the stakes got a lot higher, faster. Are you noticing that more often?
That's a great example, and I think that some of the intersection between supervisory and enforcement, there's a leverage point there, and I believe that in our example that the supervisors were able to exert leverage over the consumer actor because there is an incentive for companies to want to work with their supervisors and try to resolve potential problems through that process, which is usually more private and doesn't result in a public press release and so on and so forth. And so I think that, even from the more inside supervisory and examination process, there's an activist opportunity that the different offices seem to be embracing, and that they're responding to, a desire by consumer providers to, in good faith resolve issues, but also to mitigate the bad press and the fallout that comes from a more escalated open enforcement action by an attorney general.
So the posture from state AG is clearly high. So our thanks to Meredith Boylan and Allison Baker. Thank you both for sharing your insights. And coming up, what's new at the FTC and potentially big developments, yet another sign of new management. But this one again, at the CFPB, the CFPP, I think I mean CFPB. As we mentioned, now she's been confirmed as director of the CFPB, and the big questions are, what course will Kathy Kraninger chart for the agency now that she'll oversee it? At least by statute, for 5 years. Will she follow the path set out by her predecessor, Mick Mulvaney, or go her own way? She's already rolled back what some have called Mulvaney's pettiest move, the name change. But while expensive, what else might she do, and how might she do it? And those are questions I think many of us are asking. And in the meantime, what's going on at the FTC? So to discuss all of that, those topics aforementioned, we've got Andy Arculin, Allison Baker, each CFPB alum, and Ellen Burge. So Andy, what strikes me is not the name change, but that Mulvaney left behind an entire new layer of management. What do we make of a new CFPB head, the second within the past year?
So as far as Director Kraninger goes, it's, in my view, way too early to tell what direction she's going to take the agency in. To date, the public statements that she's made have been that she fully intends to protect consumers, but some departures from the Cordray era will continue. There's been some messaging about no presumptions of guilt. There's definitely there's a strong emphasis on reducing paternalism by the CFPB and focusing on consumer choice. One of the things that I think will be critical for the agency's trajectory moving forward are the changes that Mulvaney made to the management structure before he left. So if you recall, he created new positions called Policy Associate Directors, PADs, and those they essentially are political appointees who are put in charge of the various associate directors in the different offices at the Bureau. The most notable, I think, is Brian Johnson, who's the principal policy director, as well as the acting deputy, presumed to be the permanent deputy after Kraninger appoints him. Brian is very conservative. He was an alumnus of Jeb Hensarling's circle. He worked for Jeb on the House Financial Services Committee, and he's made several statements about his philosophy, which I think will be very influential on Ms. Kraninger. His philosophy centers around freedom of choice, informing consumers, and disclosures, as opposed to paternalistic rulemaking. So if you read through the tea leaves there, what does that mean? You look at two examples, the ability to repay qualified mortgages rule, which the CFPB did back when I was there. That, really was viewed by many in the market as a value judgment as to what is a good mortgage, what is a safe mortgage. He's made some statements about those rules, and the CFPB is in the process of revisiting them. I would expect to see more openness to non-qualified mortgage or expansion of what is a qualified mortgage under this administration. Another is the payday small dollar rule, which we'll talk about in a bit. That's one where the CFPB had really determined that payday loans were bad, more or less, and made it very difficult to originate them in their existing form. What we'll see under this new management is an emphasis on allowing consumers to make choices, providing disclosures. I can tell you there was a lot of debate during the Cordray years when I was there about how effective disclosures were and whether the agency needed to, quote, protect people from themselves, as opposed to just giving them a disclosure that shows them, yes, this is a high interest rate loan, and letting them make the choice for themselves. That's likely to continue. I think that's probably the most important change, and those appointees are going to be Ms. Kraninger's most trusted and closest advisors. So she will have full autonomy. She's going to be the director, but any director listens to the people that are around her, and those will be her chief advisors. Another thing I'd point out, the Office of Innovation was also a Mulvaney creation. I expect to see a lot of movement there. In a little bit, we'll talk about the CFPB Sandbox proposal and their no action letter policy, but there's an entire office now dedicated to promoting innovation that's very interested in FinTech. And I expect the CFPB to take a more active role there rather than a more aggressive enforcing role.
Right. And your comments about Brian Johnson, I completely agree. There's a terrific article, actually really almost a transcript of his speech that he gave a couple months ago, late November, early December, in Forbes on their website, that he goes into great detail what his philosophy is, and you can really link it back to really what had been the past year of activity in the Mulvaney administration and presumably would continue. But, Allison, like many of us, our whole group, we've got some matters at the Bureau on the enforcement side particularly, or sometimes stemming out of supervision and examinations, that are old. Some of them go back, to the early days of the Cordray area, and some matters that ended up in litigation even, and are still out there. Now, obviously, we can't get into great detail on the specifics, but when CFS lawyers and compliance staff read reporting that Kraninger says to employees, quote, "We must do our work with an open mind and without presumptions of guilt, and always carefully weigh the cost and benefits to consumers of our enforcement activities." What do you make of that for existing open investigations, in some cases that go back again to the Cordray era?
So I think that it's in some ways too soon to tell specific to her, but what I make of that statement generally is really two things. One, there are a category of investigations, more than litigation, that the Bureau initiated during prior Director Cordray's tenure. Some number of those closed, including a couple that this office handled, that my team handled. And those closed, I suspect, in part because if you were looking at them objectively, there really wasn't the evidence to back up the allegations, candidly. And I think that, the difference between certain investigations that might have been opened into business industry sectors that the Bureau just didn't like, versus practices that were actually potentially illegal. I think that that's one distinction that is mission critical here. The other is, look, there's a number of cases that are pending that were brought during prior Director Cordray's regime, and those cases are still pending in federal district court. We have some of those cases, other parties are involved, and I don't think that the Bureau is necessarily going to walk away from all of those cases, throw its hands up in the air and say, we have a new regime. What I think you might see is a greater willingness potentially to entertain settlement, or maybe to take a less aggressive posture in court as needed. But I think that to the extent the Bureau has gone through the effort of filing a lawsuit, their position is that this is susceptible to the litigation and we're going to see it through. And unless someone wants to settle with us, we're intending to take this to trial. And that hasn't really changed. And I don't think it's going to change. And I also don't think you're going to see a situation where investigations get opened and shut simply because someone calls up Director Kraninger and says, we don't like this. And actually what you may see is fewer investigations, but investigations that are stronger in evidence and stronger in potency than previously, because there won't be, the resources won't be as dispersed as they previously had been.
Yeah, and picking up on that, Ellen, my strongest memory from when I was in law school, clerking at the FTC, was looking at bound volumes of proceedings, just back when everything was just published and put in nice, fancy books, literally, and noticing that their output was lower in Republican administrations, but that perhaps the cases they were bringing were more impactful, as Allison mentioned, what we think might be occurring at the Bureau. So I know it's too early to do any statistical analysis, but have they been slowing down at the FTC, or at least in some areas in the consumer protection fraud areas? Is it business as usual?
Well, from our perspective, Jonathan, it really is business as usual. Maybe even as much as it ever has been, just as aggressive as it has been. We really, from the work that we've seen here, have not seen much of a change. And some of that may be, even though we've got a slate of new commissioners, a full slate of 5 commissioners actually. The staff that works these cases, the head directors of certain divisions that work a lot of these cases that we deal with really have not changed. And in fact, they've just become more experienced over time. And these are their cases. They are very good now at connecting the dots, looking at a case full circle from end to end. So if it's a consumer fraud case in debt collection or payday lending or whatever it could be, they're not just looking at at a main party that conducted the activity, but the lead generators, the payment processors, fulfillment companies, the whole full circuit. And they're not just looking at companies, they look at individuals. So we're seeing all of this really ramp up. We did not see a slowdown in investigations in 2019. We think some of the efforts by the Commission to extract settlements and monetary penalties are increasing. Some of the injunctive relief, I think, has been manageable to a certain extent, negotiable, but the monetary relief we've seen, especially and as it's extracted from all parties in a transaction, has really it remains remarkably aggressive to us.
And Ellen, I think what's interesting too, and as reflected on the slides, there are a number of offices within the Bureau of Consumer Protection at the FTC that actually touch financial practices, even though it may not be specifically the group that is tasked with financial practices. You've got a whole menu of different areas that are covered by advertising practices, the privacy folks, and more. Some of them, they're not necessarily focused directly on financial products and services, but they're certainly touching the area, right?
They sure do, and you could see a case come out of any of these divisions, and the cases will expand and they can overlap. You could have a case that starts as perhaps a deceptive advertising case, a claim about a product, a claim about how much we can save you on payments, or whatever it is, how much we can improve your credit score, whatever it is, that can bleed into a case about marketing practices. How were you advertising? Were you on the phone doing telemarketing, which is more of a marketing practices division issue versus advertising practices. And of course, fair game for the financial services division. Privacy and data security are always such a key. It's been a hot button issue for many years now. It will be, of course, going forward. We'll continue to watch how self-regulatory frameworks in that space and others, touching this space might be helpful. Of course, the FTC has, to a certain extent, limited resources, and the FTC in past administrations, and currently we know that there are people that are very major fans of self-regulatory efforts. So to the extent those could come in and be helpful in the industry, that's something that we continue to watch as well.
Well, thank you all. Coming up, specific rulemaking on the horizon. We've got also FinTech and more. When we come back, we're just going to take a brief 1-minute break as we pause for just a minute. Welcome back. When the CFPB first got underway, there was a lot on its agenda, and by 2017, while it had completed work on mortgage rules that Andy worked on and managed, and others, there was already signs that it had fallen behind on its regulatory agenda. In fact, the CFPB had already made a bit of a U-turn on plans for debt collection rulemaking, claiming that it would, quote, move forward more quickly with a proposed rule to focus on disclosures and treatment of consumers only, and then separately handle one for market-wide rules to address issues of rights of consumers and the right amount, after previously having said that they were going to do it all in one. And then there was the payday lending rule that got all the way to be essentially becoming effective, depending on how you were reading it and what courts you were looking at, but in any event, never got enforced, never really got fully underway, and it got bogged down in management changes and politics and concerns about operational implementation and relevance as the marketplace changed rapidly, even almost well before the rule even was put into writing. So to help us sort through what's now on the regulatory agenda, we're joined by Andrew Biggert, Andy Arculin, and Laura Biddle. So the Consumer Financial Protection Bureau said towards the end of last year that it's going to be focusing on a number of regulations, but a smaller but perhaps more impactful group. Andy, what do you make of all that? What's the latest?
So the latest is the CFPB Regulatory Office is actually quite busy. They have a lot going on, and so some of the key efforts are outlined on the slide. The other thing I would add is there's a look back to the mortgage rules as well, which, there's a lot of anticipation of changes. There's the ability to repay qualified mortgages rule. There's presumably going to be some changes to what constitutes a qualified mortgage. There's current leveraging off of the GSEs, off of Fannie Mae and Freddie Mac, that need a permanent solution that sunsets in 2021 or whenever the GFEs come out of conservatorship, whichever's first. I'm betting on 2021. But in any event, that's happening. That's behind the scenes. In addition to that, there's the small dollar lending rule, which Jonathan talked about, the payday rule, whatever you want to call it. That rule was done. It was not, it was not invalidated by Congress the way that the CFPB's arbitration rule was, but Mulvaney put a halt on it and has basically opened it up for reconsideration. That effort is underway. So there's expected in 2019 to be a proposal to revisit that rule either in full or in part. What does that mean? It's hard to tell. We have not seen the proposal yet. A couple of things I'd note for those in the industry: the rule can't just be repealed. The CFPB spent a lot of time and effort building a record for why it was necessary. So if they are going to change it, if they are going to propose changes and either eliminate it entirely or roll back parts of it, they have to have justification for doing so. That's what the notice and comment rulemaking will be about, in my mind, and that's consistent with what I'm hearing from within the agency. There's also the debt collection rule, which Jonathan talked about. Another bit of inside baseball I'd point out: Tom Paul, who's now the PAD in charge of research, markets, and regulation. He's a former coworker of mine who had left the agency and is now back. He is in charge of that division and was formerly in charge of the debt collection.
He gets a second bite at the apple.
He does, and there's the rulemaking is, again, it's pre-rule. A proposal is expected. To the philosophical differences between the Cordray administration and the Kraninger administration that we talked about earlier, the first leg, to no surprise, is about disclosures and communications with consumers. So that's where they'll start. There'll be a proposal, an opportunity to comment, and then at some point thereafter a final rule. Two others I threw in, just for good measure. HMDA is still underway. There's still some tweaking with the HMDA transactional thresholds. And one that's of interest to me in particular, property assessed clean energy, PACE. These are tax assessments for clean energy. So if, there's a number of state programs, they're financed through state bonds or municipal bonds rather, where a tax assessment is put on your property that can be used to finance solar panels or other clean energy initiatives. Not very popular within the lending industry because it's a tax assessment done through basically a government corporation.
About 30 states.
About 30 states and growing, and the CFPB was directed by Congress a year ago to conduct a rulemaking on ability to repay. One of the controversies with these PACE assessments is they're not bound by Truth in Lending Act, ability to repay, all of these things, disclosure rules and so on, that mortgage lenders have to comply with. And there's a question as to what repayment ability even means in this context. So the CFPB will be revisiting that, or will be visiting that for the first time as well, which will be an interesting thing to keep an eye on.
And, Andy, we've mentioned sandboxes quite a lot. We're not talking about places to play, but rather regulatory sandboxes. And that's something that could really be entirely new for existing products and services in terms of opportunities to get perhaps regulatory relief on areas of concern, but also for new products and services, innovators, entrepreneurs, when it comes to scoping out their compliance plan and framework. There's always a question of square peg and round hole, how to make the regulatory framework fit something that perhaps was not anticipated. Oftentimes, that may be something where there's a risk calculation, but there is potentially now a new avenue to take, either for the individual company or for the industry associations themselves.
Right. So this is, I mentioned Paul Watkins earlier, who joined the CFPB last year, I believe. From Arizona. He was the pioneer of a Sandbox program in Arizona, a FinTech Sandbox program as well. And this is the CFPB has essentially three different proposals that have been made, one about trial disclosures, one about product sandboxes, and one about its no action policy. They all fit together. Essentially what this gets to is the CFPB's newfound commitment to promoting innovation and partnering with the industry in order to foster the development of new products and services in the financial industry. It is a change. The CFPB under Cordray had an initiative called Project Catalyst, which, to be frank, no one used.
One company did.
One company, right. It was basically a soft no-action letter where the requirements in order to apply for it were to give a bunch of ammunition to the CFPB, a bunch of sensitive information about your product, and then the CFPB could evaluate it and make an informal recommendation with a bunch of caveats not to pursue an enforcement action against you. As you can guess, that was not a very popular initiative, and the risk-reward calculus simply was not there.
It was abysmal.
You're right. and what the CFPB is doing now, their no-action policy and their sandbox, their trial disclosures, are intended to make it easy to apply, limit the amount of information that someone has to give in order to actually increase participation. And, I was at a meeting at the Bureau last spring about this subject with Mr. Watkins and others, and one of the issues that kept being discussed was, well, for the no-action policy, it's great if the CFPB won't enforce against us, but we're state licensees, or we partner with banks who are regulated by the FTC or the OCC and so on. What about them? That apparently resonated with Mr. Watkins because one of the components of the new proposals is actual exemptive relief, so that the CFPB has authority under various statutes to exempt a product or to exempt a service from coverage under the law or exempt the actual company. And that's one of the proposals that's open. It's somewhat controversial. There has been some pushback from consumer groups.
And the connection to Dodd-Frank and the actual statute and their powers may be a little iffy.
That's exactly right. Yeah, there's also just some legal question about their authority to do so. And, it has not been finalized yet, but we'll see where they go with it. It's encouraging, to say the least. I think what we'll see is a lot more willingness to participate. There's a lot more of a reason why someone would, and the application process being streamlined. If you're a FinTech company and you want to bring in a new product and you're really not sure how it fits under the Truth in Lending Act, you're really not sure if your algorithm creates disparate impact or something like that, there's various reasons why you may do it. It's a good opportunity to get your product into a safe harbor to test it out. And, the testing period may go from 2 years to infinitely. That's also unknown.
That's right. And to the extent that even the foundation for this process is created now and it's used in years to come, it could go a long ways to, creating an environment where compliance and business teams can be aligned as opposed to sometimes having to operate in a gray a gray zone when a new product or service is launched. So, Laura, a question for you. Now, we've talked a lot about the FTC and the CFPB, but your wheelhouse covers banking agencies. What's your read on regulatory activity out of the agencies? Certainly, FinTech and chartering is one of those items, but there's others too.
All right, Jonathan. And of course, the regulatory activities of the federal banking agencies and the consumer financial services space is more limited, given Dodd-Frank's transfer of those roles to the CFPB. However, there are two agenda items in particular that impact the provision of consumer financial services. And the banks the agencies can impact the way their regulated entities, the banks, offer those services. And we have within the last year, two new leaders in the agencies. In November 2017, Joseph Otting became the comptroller of the currency, and in May 28, Jelena McWilliams was appointed chairwoman or chairwoman of the FDIC. And they both have FinTech charters on their list of priorities for 2019. And the Federal Reserve, though, has not yet publicly weighed in on the charter. We understand they're considering it, and we're going to talk about that later. I think right now what we should talk about is, and something mentioned by Andy, is the priority for the OCC and the FDIC on small dollar lending. Now, the federal banking agencies have had a love-hate relationship with small dollar lending that dates back to at least 2000. They want banks to lend to the underserved, but the parameters they put around it tends to make it essentially unworkable. Following the CFPB's payday lending white paper in 2013, each of the agencies put out guidance that on deposit advanced products that effectively precludes banks from offering them. And then shift to October 2017, when the CFPB finalized its payday lending rule, the OCC rescinded its 2013 guidance. And then in May, this past year, it issued core lending principles for short-term small dollar installment lending, which essentially advocates responsible short-term small dollar loans, typically 2 to 12 months in duration, with equally amortizing payments, meaning it's an installment loan that has to pay out within a certain period of time. The FDIC has not rescinded its guidance. In November 2018, it issued a request for information, including specifically what steps the FDIC can take to enable banks to offer these products and respond to consumer needs, but then again, that are quote-unquote underwritten and structured prudently and responsibly. The FDIC, or the Fed, has not rescinded its guidance. So there's a lot of uncertainty now in this space, at least for banks that are not regulated by the OCC. Now, U.S. Bank, an OCC-regulated bank, did launch a small dollar product. So they've taken this challenge, but they did it in conjunction with the OCC to help them develop it. So the framework they have is that the borrower must have a checking account. At the bank, loans can be anywhere from $100 to $1,000 in $100 increments. $12 or $15 fee for every $100 borrowed, so not interest per se. Loans are repaid every 3 months. You cannot reborrow within 30 days of having paid off the loan. There are no prepayment penalties, and the loan payment can't be more than 5% of your gross monthly income. So it'll be interesting to see if the OCC-regulated banks will take up this challenge, and then we'll look for something more definitive out of the FDIC and the Fed.
So you've got this, the bank, non-bank differences here, and then, of course, there's this sort of the federal-state tension or parity, depending on the type of organization somebody is and how they want to deploy capital. Aside from all this federal stuff, though, Andrew Biggert, there's been some movement on the state regulatory front. I know we are not going to be able to go into every state and every trend, but I know you've also, though, selected a couple, particularly from California and Maryland, too, that highlight some perhaps trends that we're going to start to see in other states, and certainly some issues that are somewhat cross-cutting, even though they're specific examples here.
Yeah, thank you for that, Jonathan. And I do think it's important not to lose sight of the states, especially for companies that do operate across multiple different states. It can definitely be a challenge to keep track of what's happening. And as Meredith and Allison talked about earlier, the states have been aggressive in the consumer financial space. So we've got on the slides a couple of examples. We're just going to hit these really quickly and then move on to some other interesting topics. So starting in California, where they've been very active. The California Department of Business Oversight has recently sent letters to 20 different consumer installment lenders asking information about their annual percentage rates and their lead generation activities. I think the focus of this is in part to start gathering information for the DBO to decide whether or not to adopt rules that govern how consumer finance licensees consider borrowers' ability to repay when making loans. So that's something definitely to keep an eye on. Turning to the commercial side, a statute was passed in California that creates a new requirement for consumer-like disclosures on certain commercial finance products, including small business loans and merchant cash advances. And following that, the DBO is required to adopt regulations addressing details such as disclosures and calculation methods for fees, et cetera, et cetera. The comments on that are due January 22nd, and there's a whole range of different topics that the DBO is considering for rulemaking.
We see those in other states from time to time, too, and commercial lending is definitely an area that a lot of folks are looking to regulate just as if it was consumer lending, and then in some cases, some states have actually carved it out, too, and gone the other direction.
Yeah, and California in many cases is kind of the leader when it comes to looking at different issues, so it will be interesting to see it, I think as you alluded to earlier, Jonathan, whether or not some of these developments end up spreading into other states. And then finally, I think worth touching on, as most probably know, California recently enacted pretty sweeping legislation called the California Consumer Privacy Act, which impacts all sorts of different industries that may be gathering information on consumers and what they do with that. And just to point out that the California AG is moving forward with developing rules for what they call the CCPA, and we'll be holding statewide forums to collect feedback in advance of rulemaking that's to come, with these forums taking place in a number of cities between, I guess, yesterday and February 13th when they conclude.
Yeah, and very important point there, too, the overlap or not overlap between what somebody's existing privacy compliance framework might be for their product or service versus what now would prospectively be required in California could be entirely different in terms of, particularly on the advertising and marketing side and the use of data. But then also, too, from an advocacy side, we expect this next year is going to be filled with a lot of folks looking to tweak the law, in some places institutionalize different changes. So this is far from being just a one and done move forward, but at the same time, the compliance deadline's coming.
Yep, absolutely.
So another development I know you were tracking was some developments in Maryland, but it's also reflective, again, of sort of heightened powers that financial regulators are getting. Andrew?
Yeah, so just another state to bring to everybody's attention. A new law went into effect in Maryland at the end of last year, basically making a lot of changes to the consumer protection law, such as, for example, adding abusive practices to the existing UDAP standard they had there. So that's kind of following the CFPB example. Just to touch on two areas that may get rulemaking or additional kind of focus in the future. Maryland will be looking at FinTech regulation, and one of the offices in Maryland will be preparing findings and recommendations for the General Assembly next year to consider on FinTech regulations. And then there also will be studies that are going to be done on cryptocurrencies and related matters as well. So those are two areas that may be of interest to keep an eye on.
And certainly when a state adopts abusive as a concept, it changes the calculus from just being nuanced risk calculation to what potentially could be sort of systemic risks, not just to the entire enterprise, but whether or not a product or service itself is favored by the state or not. And, that brings us to the issue of, what does all of this that we've just discussed mean for compliance initiatives? So for those topics, we're joined by Laura Biddle again, Ellen Burge, Andrew, and Andy. Leading off with Laura, with the state of play at One Access Banks and all this talk of changes on the consumer side, what's the takeaway when you're thinking about folks that are trying to develop their compliance programs and assess whether or not they have what they need, looking at all this?
So for banks, Jonathan, compliance and effective compliant management systems are nothing new, and they continue to be key to any compliance examination. In particular, the agencies will continue to focus on risk management related to third-party relationships, including FinTech partnerships. And as banks are aware, each of the agencies has issued guidance in this regard that has been outstanding for a while. So this is where it becomes important for FinTechs looking to partner with banks and things that they'll need to consider in their systems. So when entering into partnerships or other arrangements with banks, there are a number of things that non-banks or FinTechs must keep in mind. Banks can outsource a service, but they can't outsource the responsibility for the activity, including compliance with the law. So they're required to have comprehensive risk management programs in place to manage the risks associated with their third-party relationships. These include requirements like initial due diligence and ongoing monitoring and oversight of the arrangement. Their third-party contracts have to have provisions such as internal control requirements, audit requirements, or audit rights, reporting requirements, business continuity plans, regulatory compliance, all the things that the bank has to manage on its own. It has to make sure that the service provider or the FinTech company is doing for them. And also important to know is that bank regulators generally have the authority to examine third parties with respect to the services they provide to banks, not a deep dive into all arms of your operations worldwide, but with respect to the particular service that they're providing the bank. And contracts will generally require that the partner or the service provider acknowledge that right.
And Andrew, we're seeing that too in M&A work related to non-banks, where dotting your I's and crossing your T's is equally as important. You could have loan portfolios that need to be reviewed and could have systemic problems. You're seeing compliance management systems be a proxy for the deep dive, at least initially for first round diligence. What's your take?
Yeah, I think if you talk about systemic risks, just kind of stepping back to where we were earlier, I think under the prior administration, you might have viewed certain industries, right, as being just presumptively higher risk, kind of that presumption of guilt that maybe Andy was talking about. And I think the perception now is that maybe there's not quite as much as that there, but certainly there's still, individual risk that comes with specific practices and specific laws. So I think that in the M&A space and the investing space, which we've seen pick up a lot, that you still have to focus
quite a lot.
Yeah, quite a lot. It's still very critical to look at companies and understand where the risk lies. It may not be quite as a big picture risk as there may have been a few years ago, but if they've got deficient policies and procedures or deficient practices that they've got, that still presents risk, and there's still federal and state enforcers out there that are going to be looking at those.
And Ellen, in your experience, that's not just the core consumer financial services laws, but that's also just generally consumer protection laws that could wreak havoc on a compliance program, be analyzed, scrutinized, and in some cases make or break a deal.
Yeah, this goes back to, I think, a theme that we've heard today, which is really to look end-to-end at everything you do. It's not just the main service you're providing, but how are you providing it? How are you generating your leads? Are you getting people on the phone? Are you texting them? Or all of these things, any one of those little things can trip you up, and that just opens the hood of the car for everything to be reviewed.
And Andy?
And so one thing I would add, just more an observation than anything, I've seen a lot more risk appetite since, especially since Cordray stepped down at the CFPB, And, you know, in an environment where, depending on the loan product, mortgages are a really good example, there's a ton of competition and margins are tighter than they were a couple of years ago. So in my practice, which, you know, I do a lot of work in the mortgage area, two areas in particular are loan officer compensation and RESPA, strategic marketing agreements and so on. There's, you know, 2-3 years ago, basically everyone was scared stiff of the CFPB. All loan officer compensation plans were as vanilla as they could be to comply with a pretty confusing low comp rule.
Just avoid certain.
And there was really, you know, there was no appetite at all to enter into marketing services agreements with companies that may refer you business because of RESPA's prohibition on kickbacks. I'm seeing a lot more willingness to go back into those areas now and getting more work around developing products within the safe harbor, within the RESPA safe harbor, or developing compensation plans that allow banks or lenders to pay their top producers, perhaps more than they pay others, and not weigh into fair lending problems or LO comp problems. That was not there a couple of years ago. And, you know, one caution I would throw out there is be very careful. If you're going to take a more aggressive stance, don't just assume because the CFPB has not had an enforcement action in the last year or so that you have no risk. There's private rights. There's lengthy statutes of limitations for the agencies themselves.
Well, in some cases, these loan products go a long time, too. So
they do.
The statute of limitations doesn't start or stop until, you know, well after this administration's long gone if you're dealing with a 30-year mortgage, for instance.
And there can be buyback risk from your investor. Exactly.
Okay, well, very important, and so Full Employment Act still for compliance officers and departments and legal counsel. But, you know, that brings us to, well, the lack of, if there's a lack of compliance or perceived lack of compliance, whether in truth or in fact, there can still be enforcement activity. Now, we've touched a bit on enforcement activity already, but, you know, Allison Baker, you know, what's next from on the enforcement front? What are the trends, and you know, where are we seeing the activity?
Sure. So I think just to kind of continue in the same vein we've been discussing, I kind of see a few things emerging. One, I do not think Director Kraninger is going to forego enforcement activity. I think that she's going to be very deliberate and very decisive about what enforcement actions the Bureau takes. I think you'll see an uptick in investigations post-Mulvaney. So number one, I definitely would keep my eyes peeled on that and be very mindful of that. Number two, something that I think my colleagues have already talked about at length, Andrew and Meredith in particular, you're going to see an uptick in and continue to see an uptick in state regulatory enforcement actions. So state regulators, licensing entities that kind of have a quasi-enforcement role but have really expanded that role in recent years. You're going to definitely see that continue, especially as there continues to be a gap, what I call the innovation gap. A lot of products and services being introduced in the financial services market are not necessarily contemplated by outdated rulemaking. And Andrew talked a bit about that before with respect to California and Maryland and other states. We're definitely seeing an uptick in that. And then number three, you're going to continue to see state attorneys general aggressively pursue enforcement activity in a lot of consumer-facing industries, both because they see and continue to see a gap in enforcement on the federal level, and also because a lot of times it's really a continuation from what has been going on the last 5 years in the AG space. And so I think those are the three big enforcement trends that I'm seeing and that we expect to see in 19.
Thank you, Allison. And, you know, now that brings us to the future of bank FinTech partnerships. Certainly a hot topic, and one that even touches folks on the debt collection and debt buying front who may be looking to buy those receivables at some point in the future or collect on them, to those who do advertising and marketing on behalf of bank partners, or those who are doing direct lending but might want to connect with a bank in the future. So, Laura, Andrew, and Andy, I'd like you to weigh in on, you know, what's pretty significant policy shifts taking place that could really open the door to a lot of opportunities, but aren't necessarily going to be for everyone. You know, the landscape for FinTech is complex and diverse, but you've got, you know, automation and AI operations. You got routine procedures and compliance. All that can be wrapped into FinTech and the use of technology with, you know, even marketplace lending, of course, insurance and credit and risk analysis, currencies, and so much more. They sound abstract. They're all easy to put under the FinTech bucket, but some have some real-world impact and compliance models and ultimately the type of services that are provided. So, a lot of these areas are already regulated in some way or could touch, depending on the regulator, state regulation, and somewhat, of course, on the federal level. But for non-banks and then for banks, there's an overlapping framework, and it's complex. So let's unpack this for just a short while. Laura, some people may consider it a regulatory arbitrage meets wishful thinking situation. Others have said it will open up entire new possibilities of offering credit and related opportunities to consumers. But where do the OCC's chartering proposals stand, which would essentially, flatten state regulation to a one-size-fits-all type approach that certainly seems more efficient for those that could meet the criteria. But there's also that question of, who would meet the criteria?
Thanks, Jonathan. And maybe we should just start with what is the business of banking, and how is that driving the success or failure of the FinTech charter, or the OCC's FinTech charter. So the business of banking is generally considered to be the taking of deposits, the paying of checks, and the lending of money. For the most part, all banks take deposits and have deposit insurance. There are certain non-traditional banks, often called CFPB banks, for certain legislation that authorize them, or non-bank banks that have limited deposit-taking ability. These are like credit card banks, non-depository trust companies, and industrial loan companies. The National Bank Act gives the OCC the authority to grant charters for national banks to carry on the business of banking. The OCC in its regulations has long defined the business of banking as to include any, but not necessarily all, of the three core banking functions: receiving deposits, paying checks, and lending money. So this would seemingly permit the OCC special purpose FinTech charter to move forward, but it's more complicated than that. As there are other laws that come into play, which is unfortunately beyond our short time today, but we are putting together an article analyzing these, so if you're interested, look forward to that. To date, no applications have been filed. This is likely due to pending lawsuits, which Andrew will talk about more, which make the charter, at least in the near term, uncertain at best. So for FinTechs, a full bank charter may not be practical, either due to deposit-taking requirements and deposit insurance, or the nature of the activities conducted by the parent company. For those willing to take deposits in some manner, an ILC charter may be an option. This is something that Chairman McWilliams has made a priority, or at least the consideration of charters a priority this year. So an ILC is essentially a deposit-taking bank whose parent company is not subject to bank holding company regulation. The lack of holding company regulation has made the charter very controversial. Only 7 states offer the charter, and today there are only about 30 charters. No ILC has been approved since well before Dodd-Frank. Last year, 3 applications were filed, all by FinTech companies, including Nelnet and Square, and they were all withdrawn. And what that usually means is that, as proposed, the FDIC is not going to approve it. But Square did refile its application in December. So that'll be something to watch.
So, and Andrew, a lot of movement, though, on states reacting. In some cases, if folks want the charter or banking, some form of banking authority, to avoid what otherwise is the melange of state regulation. What's your quick take on that?
Yeah, so I think the quick take is that the FinTech industry really does sit at kind of an intersection of what's happening at the state level and what's happening at the federal level. And the OCC charter certainly is one aspect of that. But, the states haven't necessarily reacted positively to that. Obviously, there have been lawsuits that have been filed both by the Conference of State Bank Supervisors and by the New York Department of Financial Services, challenging the OCC's authority to even issue the OCC charter. So those cases are pending right now. We'll have to see how those get developed. But a lot of the states really aren't even just sitting still there. There have been a lot of developments in terms of trying at the state level to streamline some of the license application processes that are out there for money transmitters, for example, or perhaps for state lending licenses. And the states, through the Conference of State Bank Supervisors, have been trying to find ways to basically streamline and facilitate the process so that companies that are looking to roll out a FinTech product that may have licensing implications across multiple different states don't face quite as big a burden in order to get the licenses that they need to operate.
And Andy, that burden is not just felt by direct lenders or perhaps service providers on the lending side, but it can also be the advertisers and marketers. Obviously, in some cases they could be brokers, or in some cases at least the states could consider them being brokers.
Yeah, that's right, and that's, we were talking earlier about round pegs and square holes and statutes that were designed with other parties in mind. I think you're touching, Jonathan, on lead generation and marketing companies that market credit products. They often are regulated as brokers, whether it's a mortgage broker or just a loan broker, and that can be a challenge, especially given how complex the state statutes can be and how they may exempt loans made by certain parties like banks and others. So that is an area that continues to be, the states struggle with it. The states have been forming new licenses or new regulatory regimes to cover marketing and lead generation companies, and that's an area that continues to progress.
Well, there's so much more we could discuss on FinTech. The true lender Madden considerations, perhaps that'll be resolved in 2019, but I'm not so sure. The ability to structure partnerships that make sense economically but also comply with laws is just a challenge for folks, and it's something that I know we're dealing with every day. And then, partnering. Increasingly, partnering seems like a good end run sometimes around the core regulations that a company might have to follow, like, for instance, getting a license if they're a service provider or whatnot. But at the same time, you're opening yourself up to service provider oversight, lots of oversight, monitoring, and diligence, and perhaps a never-ending stream of questions from that bank partner that it allows you to do the lending, but nonetheless requires a full-time compliance and legal team to answer their responses. So with that, one last plug. So keep an eye on your inbox for our monthly Consumer Financial Services Digest. It's a terrific resource. It's one that encompasses all of our latest articles and publications, conference presentations in particular, particularly if you didn't get an opportunity to go to the conference. If we've presented, oftentimes we will feature the PowerPoint presentation and other materials. And so, again, feel free to take a look at that at venable.com/CFS/publications. And also, for some final observations, just like to go quickly, just one take around the room. Outlook for 2019, Allison?
Keep your eyes open, because I don't think the Bureau is going to sleep. I think the federal other agencies are going to continue to do their job, especially the FTC, more aggressively than before, and it goes without saying that the states are not relenting.
Andy?
If you're an innovator, if you're in FinTech, and you're considering what type of product you want to bring online or what business initiatives you want to bring forth, give careful consideration to compliance. Consider applying for the CFPB's Sandbox. Give that some serious consideration. And regardless, I think there's a lot of new technology out there. There are a lot of new algorithms. Be sure you test them before you take them to market.
Meredith?
Be prepared for some potentially unexpected bipartisanship across the AG spectrum. Notably, one of the recent settlements noted specifically that it was the largest settlement with a bank that did not involve a federal partner. So the state AGs are working together in surprising ways.
Andrew?
So I think from the business opportunity perspective, there's a perception there's a lot more opportunities out there, whether M&A and investment. And I think that's great, but I just think that the positive environment shouldn't be a situation where people cut corners, because that'll just come back to haunt you when it comes time to try to sell your company or if you're looking to get investors.
Ellen?
Take a close look not only at what you're doing internally, but what are your business partners doing? Are they doing things that could potentially come back to haunt you?
Laura?
On the banking side, watch for FinTech availability. FinTech charter availability and ILC charters. And in the meantime, if you're looking to partner with a bank, go in it knowing that you may be needing to be an open book to both the bank and the bank regulators.
And finally, keep an eye on the rulemakings at the Bureau. In the short term, they could have long-term implications for the respective areas of focus, but also the next 2 years could be a significant narrowing window of opportunity for folks that are looking for regulatory change and the change in posture and tone. Elections have consequences, and at least according to some, the Bureau director can be terminated without cause. So depending on what happens in the next election, again, could be a compressed time period, or we could be looking at a full 5 years and ultimately perhaps a 7-year run. But in the long term, for everyone joining us today, keep an eye on those 3 lines of defense. Whether you're in the thick of it or considering an investment or being a vendor, the business is always the closest to the compliance functions. Then you've got your legal and compliance departments and the internal audit and the paper trail that goes along with all of that. It all goes hand in hand with demonstrating compliance, and just because that may not be flogged as much by some agencies, it is still very much important, and is still very much what is on the day-to-day how consumer financial products and services are sized up from a legal viability standpoint. So before we go, one more reminder, you can catch many of our articles and presentations as part of our CFS Digest and on our firm website at venable.com/CFS/publications. And do say hello if you'll be at one of those upcoming conferences, or let us know where you'll be or you think we should be, and we'd be glad to meet you. We enjoy catching up and welcome your feedback on this webinar and future articles and presentations. And that's our webinar for today. As we start this new year, thank you so very much to our team that helped us put this together, our many colleagues that are a part of our group, our panelists, Andy, Allison, Ellen, Andrew, Laura, Meredith, and Josh.